Hello, friends. We're live on the Bradley J. Show with Michael Coyne, Dean of the Massachusetts School of Law, one of my longest standing guests and friends. It's wonderful to have you with us again.
Good to be with you. It's been a while.
We're going to talk about the notion of equal justice under the law in the United States of America. I used to live on East Capitol Street on Capitol Hill, a few blocks from the Supreme Court. And I would walk by and I would see the court and notice that. I didn't think much about it until a more recent visit. And I thought, really? And the more I watch, in the last 5 years, we've watched, a lot of folks have watched more cable news and a lot more courtroom activity. And it became clear that that's just not true. I see, and I'm going to give you some reasons that I feel that's not true. And you can tell me if I'm off the reservation or not. Rich or powerful are way more likely to catch a break than regular folks. First, the quality of the lawyer you can afford. There's a huge difference in the experience of lawyers, and that makes a huge difference. How long you can afford the lawyer. Can you afford to keep filing motions and appealing and all this? Because that all costs money. Then there's the tolerance of the court for endless motions and potential frivolous motions. The court seems to tolerate it much more, at least it seems that way to me on this end, if you are rich and or powerful. Again, multiple appeals, etc. And then even further, a really powerful defendant like an Al Capone or a powerful politician can actually intimidate the court, the witnesses, the jury, and have an effect that way. So it seems like there's a real huge disparity, and it saddens me. Is there anything you can say to cheer me up, or is this all true?
No, I don't want to be as negative as you are, but I think your thoughts and your feelings are legitimate, no doubt about it. I mean, the fact is, where it says equal justice under law on the Supreme Court,
right? No,
that's an aspirational goal. That's not the everyday objective. It might be, but we know that there are great disparities for those that are wealthy versus those that are of even more modest means. You don't have to be poor to not be able to afford a lawyer. Lawyers are expensive. And justice does, unfortunately, in part depend on your resources, not just for lawyers, but for the experts that you would hire as well. The fact is that if you're poor, if you're of really modest means, the court will appoint some very, very terrific and talented lawyers for you. Oftentimes, it's the folks in the middle who are struggling, don't meet those guidelines, and really are left without recourse because hiring a lawyer is very expensive. So I'm certainly not going to be the one to tell you that justice, in part, doesn't depend on the financial resources available to the parties. Because we have two pretty good examples of it right now. When you look at the Trump trials, the multiple trials that have been ridiculously expensive to both defend, especially, but to prosecute as well. And even the Karen Reed case is close to us as in Dedham, where she's got a couple of incredibly talented lawyers that are very expensive. And it has made a difference so far with her motions and her presentation to the court and to the public, because some of that matters with respect to how the public receives the case and whether justice then will be served or not. So unfortunately, your feelings are correct that too much of the justice system depends on the resources available to the parties. And that means that most of us then are going to get the short end of the stick too often.
I didn't realize you had to be a certain level of poor to get to get a court-appointed attorney. I couldn't choose to take a court-appointed attorney if I wanted to save my resources.
Nope. You have to be indigent in order to qualify. And so that's where the line comes in, is that, you have to be so poor, so of such modest means that you truly cannot afford the lawyer. Not just that oh, this is going to hurt. I'm going to have to max out the credit cards and go to the bank and maybe ask my boss for a loan. The fact is that those are the folks that are probably in the worst shape. And what happens in a lot of these cases then is people see enough lawyers on TV or on the radio here and decide that, I think I can do that job. And unfortunately, they're ill served by trying to represent themselves. And
Yeah.
the old adage is true that the person who represents themselves has a fool for a client.
Right.
The fact is, there is an advantage to hiring someone who went through 3 or 4 years of law school, passed the bar exam, and now has some experience doing what you need to have done. And unfortunately, people who try to represent themselves oftentimes make the situation much worse than it would be if they hired competent counsel.
So a case could bankrupt you, just like a health issue could. There's
Oh, no doubt about it.
there's
Even what you might look at as a simple divorce, where there's custody and financial resources and a home and maybe a retirement account that's at stake here, you could be talking hundreds of thousands of dollars before that case is over. Who has that type of money? Even a more simple cases I talk to my students about when we look at some of these issues is, let's suppose you were arrested for driving under the influence of alcohol. The fact is that might cost you anywhere between $5,000 and $25,000 to hire a good lawyer to defend you in that case. Who has that type of cash around that and if you did, do you really want to give it to some stranger who has your fate in their hands? The answer is you probably should, but it's money most people don't have, and certainly don't have for that purpose.
And for that reason, I would think there would be, just like there's medical insurance, there would be legal insurance. Can you get insurance as part of your insurance package that includes money for, like, 500 grand for legal fees, just in case?
Yeah, there are prepaid legal insurance plans. I was actually involved with one when I was in Boston. It was one of the employee benefits that were provided to the Boston Teachers Union, and other unions and other organizations do it as well, where in essence, when you have that need, just like with health insurance or disability insurance or all sorts of things, there are certain treatments that are covered. Well, here there are certain activities that are covered, and they would include sort of the basic things you might think about: a will and a trust, perhaps a defense of a criminal case, and even representation in a divorce case if that's what you run into.
So I feel like I would get that insurance because probably be approximately the price of homeowners insurance or something, because there's not a lot of people going to court every day, really. It's not like the amount of people getting sick or anything like that. I think it might be a good deal.
Well, you should look into it, but I don't think you get sued that often.
No. Plus, you can also get an umbrella insurance policy,
correct,
a liability. So maybe, but that doesn't cover legal fees. So
no, but the umbrella policy might well then provide insurance policies of that nature. Oftentimes will provide some coverage, and also most insurance policies, for instance, your homeowner's insurance policy, your automobile insurance policy, if there's liability attached to your having driven the vehicle or the home ownership, that the insurance company, as part of that policy, will provide a lawyer to defend you under the policy. But only up to the limits of the policy, so you still might end up getting your own lawyer above those limits. But the umbrella coverage and your homeowner's coverage and your automobile coverage will provide some protection in that regard, because they do have an obligation to provide legal representation to defend you under the policy limits.
And you did mention if you get convicted of driving while under the influence, there's a question I always want to ask you, and I think I always forget. And that is, if you have been drinking none, you get pulled over, they want to give you a breathalyzer. Should you do it or not?
Absolutely do it.
Okay.
Right? You've got zero. The fact, and you should cooperate to the best you can. The problem is, that's the easy one. What happens if you had a couple of drinks and over a relatively brief period?
Right.
Oh, now you have much more of a concern as to what that breathalyzer will be, because it doesn't have to be a lot. Most people think driving drunk is, you're unable to control the vehicle and you're sort of
Right.
half falling asleep. That's not the standard. The standard is that you have consumed enough alcohol that your ability to operate safely has been impaired. And for some people, that might only be a couple drinks in a relatively brief period.
Right.
They're going to be in the range where they have at least the enough alcohol in their system that while it might not raise a presumption that you're operating under the influence, it certainly is enough to support a potential conviction, because in Massachusetts, you need a 0.08 or greater
Right.
of your blood alcohol content. If you have that, then there's a presumption that you are operating under the influence of alcohol. And depending on your size and weight and how much you've had to eat and drink, that you can get there far quicker than most people think.
Right. And so if you have doubt, you think, oh, wow, I might be over. You should or should not take the breathalyzer.
You should not, but then you're also going to lose your license for
Right.
some period of time through a registry suspension, because as part of your license agreement, you have agreed to cooperate with the law enforcement and undertake a breathalyzer if requested to do so. So you'll lose your license, but you won't lose your license potentially for as long as if you're convicted of driving under the influence.
So if you have any question about it, just say no. Do not.
Well, as a general matter,
As a general matter.
But each situation is on its own that you have to look carefully at it. Plus, there are other things about field sobriety testing
Yeah.
that you'd be worried about. But I mean, if you don't have problems with your legs or your limbs, and you feel that you've had a drink, the likelihood of that affecting the breathalyzer is low. Sometimes there are obviously problems with the administration of the breathalyzer and the like, but that you can litigate as well.
Right.
But the fact is if you've only consumed really very little, then the breathalyzer is probably likely going to help you.
Okay. By the way, I know someone who has a breathalyzer, bought a breathalyzer, and before driving will check their blood alcohol in the breathalyzer. That seems to be a pretty good idea.
Yeah, I think there's actually little devices on Amazon you can buy. At least it's not as accurate as the breathalyzers that the police stations have and the like, but it'll give you a pretty good read as to whether you should put those keys in that ignition. Most people would say that when in doubt, if you think that you need to do that, then maybe you should take an Uber or a Lyft instead of running that risk.
Right. And I know we got a little off the track here, but these are good things to know, so you won't need the expensive lawyer. Oh, sorry, that one was, but this one, whenever you talk to the police, you should always have an attorney present. But what if you get pulled over and a policeman wants to talk to you? Like, where do you draw the line? You can't really say, I believe I should have a lawyer before I talk to you. I mean, that you don't want to be crazy. So where do you draw the line? How do you do, officer? Good evening.
There's a couple of different schools of thought. So it's not schools of thought on this. It's not uniform. There used to be a criminal law professor here who would tell folks, roll your window down just a crack. Now you just got to hit it with your little finger, and just put out his card that says, I don't want to talk to you. My name is X, because you do have an obligation to identify yourself to the police. But beyond that, you do not need to talk to them. You do not need to provide information, obviously because of the Fifth Amendment and the like, but you do need to identify yourself. But you don't have to answer questions about how much you've had to drink or where you've been or what you've been doing. Most people tend to cooperate. Most people believe that it's appropriate to assist law enforcement in the performance of their jobs. The problem is, from a legal perspective, their job right now is to remove people who are incapable of driving legally off the road. And that means that they're not your friend, And so a lot of times people shouldn't cooperate, even though it's in our nature too, because what you do could ultimately then mean you're going down to the station instead of going home and finishing your route. But all of this in part is predicated upon you've done something you probably shouldn't do, and now you're caught up in a situation that you're trying to defend against the worst possible outcome. The fact is, most of us are not under the influence and we're driving safely. And the ability to cooperate and our desire to cooperate with the police is the appropriate thing to do, because they're not looking to make extra work and just hassle most people at any rate. What they want to do is do their job and get home safely, just like you.
It's tough. Most people don't know a lawyer or have one to say, this is my lawyer. Maybe everybody should kind of have, just like they have a plumber and a,
it'd be good business for us.
Yeah. I mean, just reach out and say, look, just in case I ever get in a jam, I'm going to call you. Okay. Establish a little bit of a relationship. I don't know, because who do you call? It's 11 o'clock at night. You better, and all of a sudden you need a lawyer and it's nighttime. Who do you call?
Well, most people like you, as has suggested, is that, well, they'll just get me a lawyer and they'll appoint one for me. No, not necessarily. They'll recognize your desire to speak to a lawyer. But the fact is, they're not necessarily going to go hire someone or get someone for you. And especially when you think about it, even if you have that lawyer friend and lawyer contact, there's not a lot of lawyers necessarily coming out at 2 or 3 or 4 a.m. in the morning if you don't have a prior relationship with them.
Right. You're probably going to spend the night in jail.
Or be released on bail till the morning.
All right. So back to the initial topic, the primary topic, the notion of equal justice under law. And we're looking at a situation where it may be one of the least equal situations with President Trump. Pretty much all of the problems I noted in the beginning regarding rich and powerful people are in play here. And we have to speak about this trial because we're seeing these things happen right in front of us. I was surprised that one of the things that the former president could have done is fire their attorneys at the last minute as a stalling notion. It's that kind of thing rich people can do.
Anyone can do it, but let me make a counterpoint to your argument with respect to the Trump cases. The fact is, he is one of the richest and most powerful people in the world, and already 2 juries have determined that he owes almost $500 million. The fact is that, yes, he's got lawyers and he has lots of them, and he doesn't always pay them. At least that's the story. But the fact is, he is, through those resources, is able to drag these cases out and force the government to spend an awful lot of money. But at the end of the day, some would argue, I would argue, justice is served when we show that even the rich and powerful are held to account. And in this latest case, that's the same thing now. He's facing criminal charges, and it's completely unprecedented for a former president of the United States to be facing so many felony charges and the like. But some would argue it shows the system works, even if it works very, very slowly. And that's oftentimes a criticism of our legal system, is that the wheels of justice grind incredibly slowly. And in these cases, I do believe they have ground far too slowly. And in part, that's because of the defendant you have and the type of defendant. He's what we would call a scorched earth defendant. He is going to leave no stone unturned, and he's going to fight about absolutely everything. And he has the financial resources to do that. That's what makes the playing field unequal and unlevel. Most folks don't have these resources, can't drag it out. Many would run out of money, as you suggested before, way before this point, and just simply concede because it's the best thing to do. He doesn't have to because of his access to those funds.
And it's a particularly weird situation because if he can just string it out long enough, a lot of this stuff can go away. if he should win the election. Which brings me to a kind of another thing. The idea of the presidential pardon, I have real problems with that. I don't know if one person should be able to pardon a raft of people by whim. They all seem to abuse that.
So you disagree with the governor's blanket pardon for all the earlier marijuana convictions as well?
Darn you!
No, but you
Well,
can't.
first, I mean, technically, I'm talking about the president, and maybe there should be some guidelines, not just whim. The blanket, the thing for those, you can make a case that it was, not a violent crime, and the law has changed now. There's an argument rather than just, yeah, he's my buddy, I'm going to pardon him, kind of thing. Oh, and of course, I'm going to pardon myself.
That's where that really rubs people the wrong way. But that's the problem, though. So where is the bright line here where we would say, well, this qualifies and that doesn't? If the executive, whether it's the governor or the president of the United States, chooses to exercise that pardon power, how are you going to check that power? And who would get that authority if it's not the chief executive of the sovereign, either the state again or the United States? And that's where the slippery slope comes in, is that who gets to supervise whether it's appropriate to pardon or not? That's the idea of that should be the chief executive. And you know what? This may be one of these that comes to us back from when the world was flat and we had kings, right? The king's power, the benevolent king could do whatever he or she, the queen wanted, and you couldn't question that. And that may be at least the early origins of the authority behind the pardon power.
Maybe there should be some sort of panel. That would kind of eliminate the I'm pardoning because he's my friend thing. If they were, it would have to be unanimous, or there'd have to be a majority of something. And some members of the panel could say, I'm not just pardoning your friend, etc. It might be worth taking a look, drilling down a little more into this trial at the behavioral choices of the defendant, Donald Trump, and take a look at whether they might help him or hurt him. In the courtroom, he's sort of belligerent. He gets admonished for uttering sort of threatening or intimidating sounds near jurors. Does that help him? Will it help him in the long run, or will it hurt him? Will jurors be intimidated? Like, I'm afraid. I don't want to find him guilty because his followers might come and hurt me.
Well,
go ahead.
Some might be intimidated, but I think most will not be. I don't think it's wise to present a gruff, a bullying type mentality before the jury. When we try cases to juries, what we want the jury to do is be able to see the defendant not as the defendant, but as a person, as someone, maybe a family member they remind them of, or someone close to them, so that they would empathize with the situation they're in. So if you hold yourself above them, if you are of the type that oftentimes he displays sort of an arrogant and an abrasive manner, that's not likely to be well received by the juries. And they would vote accordingly. So when we try cases, we want the jury to be able to sort of emotionally wrap their arms around the defendant and see them as one of their own. His behavior oftentimes doesn't do it. And again, just compare it to the case more recently here in Dedham, the Karen Reed case. She obviously, throughout the course of her jury selection already, is trying to appear to the jury as someone that they could empathize with and see that they're in an unfortunate situation. And that is obviously, to the extent she's able to carry that off, is to her benefit. My guess is lawyers have talked to him time and time again regarding his courtroom behavior and the obligation to keep silent and not be muttering things and saying things. The judge has already warned Trump just yesterday with respect to his audible outbursts with respect to a prospective juror. He's not going to get away with that forever. But this ties to your earlier point. He's gotten away with some of that far more than most. He's gotten away with what could be contemptible behavior with respect to the gag orders and the like, far more than most would ever get from a court if it were you or I doing that in a courtroom where the judge had admonished us about making extrajudicial statements, and we continue to do so. You and I would be spending time in jail as a result of the abuse of that order.
It seems that there's hesitance to throw Trump in jail for contempt. For political reasons, people were afraid that would cause civil war. It doesn't. It looks that way less and less. There doesn't. The fear of charging him, trying him, etc., seems to be diminished. And further, as far as fearing him, there was a potential juror who was dismissed, and one of her comments was, he was in there and he was just another guy. It seems that sitting in that courtroom, all his magical powers of the great and grand Oz, he's kind of taken away. He's in, and jurors may see him after sitting there for day after day as like just another guy, and may be less afraid. That being in that courtroom does take away some of your magic power, doesn't it?
Oh, I don't think there's any doubt about it, especially with the charges in this case. The allegations are so sordid and really beneath the office of the president. I think this does tarnish his image, even among those who strongly support him. It makes it harder to continue to have that fever that they tend to have when you think at least a little bit about the details. And as much as you can argue it's a politically based prosecution, the fact is it's beneath the office of the president. So I do think it tarnishes his image, certainly among many people, but even his supporters. At some point, when you're facing 88 felony charges, it's hard to continue to argue that he should be returned to the office of the president.
Now, even though I think they decided you could not enter the fact that his wife was pregnant when he was having one of his affairs, you can't enter that is inadmissible. Still, this whole thing reminds folks of that. It's like, yeah, geez, here he is sitting in court. This is real now. And it's reminded me of the unpresidentialness of the person. And it might, like the Christian right, this is getting into a political conversation, but it's just, folks thought, oh, this is going to give him a lot of juice when he's in court. Nope, it doesn't seem that way. It seems to be working the other way. It seems deflating and humiliating and not working out well for him. Even if he beats it, it's like, you sat there in court and it was ugly.
Yeah, I'll actually be surprised if he does. Michael Coyne already went to jail on his involvement in these charges. It's not a very complicated case. I mean, the question is, did he pay the hush money in order to keep this information secret to interfere with the election? And there's no doubt that the money was paid, and there's no doubt that Michael Coyne, even the admitted perjurer he is going to explain that he didn't do this on his own. Why would anyone do this on their own? So I do think has a real challenge here, coming away with either a hung jury or a not guilty. I think the likelihood is that after a relatively brief trial, he's going to be convicted. And then we even have more issues about, so someone can continue to run for president and be the Republican nominee, even though they are now a convicted felon, even if it's going to be challenged on appeal. I mean, it's just every time we think we're at the lowest point we can be, we face yet another unprecedented situation. And I think that's likely going to happen here.
What are the odds that he would actually go to jail?
I don't think on this charge that he's likely to go to jail. I think, if the court is likely to confine him, it would be some type of home confinement for a period of time. And I think that would probably be appropriate. These charges are not anywhere near as serious as the case down in Florida or in
Right.
Atlanta, where you're really looking at serious felonies for the failure to protect the documents and the potential election interference down in Atlanta. Um, and so there's a real risk. The problem comes in is, well, how do we ensure the protection of a former president in prison?
Right.
Well, we can. We've had other high profile prisoners. The problem is the security ends up being that so significant that he ends up in isolation. And as much as people, and many people, don't care for him or feel for him, it would be a difficult situation, I think, for many
Yeah.
people to be able to see a former president in isolation in prison, spending the last days of his life. So I don't know how they ultimately can mete out the appropriate punishment for such serious charges. But that's going to be the judge's job to be able to figure out what it is that and how it is that should be carried out, assuming that there will be convictions.
Why wouldn't he have just settled this? Could he have settled it? And if he could have,
Yeah, not his nature.
why not?
Not his nature. He's 78, 80 years old. All his life, this is the way in which he's defended every case that's ever come before him. He is a scorched earth defendant. Leave no stone unturned. Burn it all to the ground if we have to. He never ever settles because this has been successful for him all his life. Because most people, as you pointed out at the beginning, are not going to have the resources to continue to fight him till the end, and they will either grow weary, walk away, or ultimately resolve it through a trial if that's what's necessary. So the reason he doesn't is this has been successful for him in doing it this way. And he's not the only defendant or company that litigates like this. There's a lot of defendants who feel that if we show some vulnerability here, then the next person will sue and the person after that.
Right.
So what you have to do is take this strong stance, and it will ultimately be a financial benefit because others won't begin the fight if they know that's what it takes to be successful.
All right. Prior to this session we're having, Dean Coyne, I did send out a few invitations to trusted folks, the kind of folks who might have called in when I was on WBZ, the trusted ones, not all of them. And, there are only 19 on the list. And one of the folks is right here and wants to join us and comment if that's okay with you.
It's fine with me.
All right.
I always love that.
This is Boston Bob, who is a caller on WBZ, and he's a good and thoughtful guy. He's in the transportation business. He's always very secretive about what he's doing. That's all right. But Bob, say hi to Dean Michael Coyne.
Dean Consular Coyne. Good morning.
So what do you have to say? What's your contribution here, Bob?
I have a technical question for you, Consular Dean Coyne. Hypothetically, if President Trump were found guilty on criminal charges and was sentenced to prison, did the Secret Service have to go to prison with him?
Yeah, I think probably, right? They're charged with carrying out his protection nonetheless. And I don't think that they would trust, regardless of whoever the prison guards were, with making sure that he's safe at all times. So I think that is likely. That's, again, the other reason why it becomes really problematic when you think about confining him in a facility where there are other prisoners present who may well want to do harm and achieve some level of fame or whatever at his expense. And so I think that's where the real challenge comes. I don't think he faces that prospect on this case. It might be a period of home confinement, but some of the other cases are much more serious with respect to the top secret documents and the like. And that the court is going to be challenged with that. And yes, I think the Secret Service agents will ultimately be present with him during whatever that confinement will be.
It's amazing. It's amazing what this country has become.
Thank you very much.
Interesting times that we live in. I tell people when we think about this, I remember Gary Hart was disqualified from running for president because they found out he had a girlfriend. Now we've got all sorts of sordid allegations about what took place, both prior to the presidency as well as during uh, in the White House during this time, and no one seems challenged by it at all with respect to the fitness to serve in the country that we have become. And it is worrisome, the level of discourse and the political climate that we have right now.
Bob, excellent question. Thank you, brother.
Thank you. Have a great rest of your day, gentlemen.
Thanks,
Okay.
Bob.
So that's cool. All right. Well, we'll see. We'll see how this all rolls out. I actually feel some relief that it's underway. It took so
I agree.
long. It took so long. You think, is it really going to happen? Really? Do we really have the wherewithal to do this? And it turns out, yeah, and it's not that hard. I do notice that Judge Marchand, if I'm saying that correctly, he's given all kinds of leeway. Part of that is to ensure or reduce the chances that things will get overturned on appeal, correct?
That's
So
correct.
super amount of leeway. It would be hard to win an appeal on this, probably.
Well, again, the fact is that the court does want to be careful not to make an error to give the defendant that additional grounds for appeal. And I think the court has done a good job so far trying to strike that appropriate balance. And the other part of that is, there are people that feel that he is being victimized here. So any further slight by the court or adverse ruling gives fuel to those that think that the system is rigged against Trump. Where, as we started with, as a former president with lots of resources, he is far luckier than most criminal defendants are in our system.
Can you really factor that in, though, how it might affect politics or how it might enrage the public? Can the court really factor that in and be fair?
The court shouldn't think of the political aspects to it, but at the same point, you do want the public, all of us as a whole, to have trust and faith in our judicial system and our system of justice, such that, again, back to where we started, that the rule of law is enforced equally, and even former presidents are held to account for their misdeeds. And so you do have to worry and think about, even and not allow it to affect your rulings, but that it will be the perception of what's taking place, that those rulings are fair. So I do think there's a tendency, when there's so many eyes on a case, for judges to be even a little more careful than they would otherwise, to make sure that it is not just justice is achieved at the end, but there's a perception that the justice process did what it was supposed to do in order to try to be fair, even to those that many people see as guilty or even innocent, one way or the other. We need to trust the process and allow the process to finish correctly what it is supposed to do, and that's provide due process to everyone, even those that you dislike, even those that are in disfavor. The fact is that the rule of law should apply equally. We know that's aspirational.
Right.
We hope that it's carried out here.
Well, you make me feel much better pointing out that, some justice has been done. I feel much better having talked to you. Thank you.
Well, I'll send you my bill.
So I do have a question. This is not really a lawyer question.
Okay.
This is just a buddy question.
Okay.
And I'm asking it to everyone who may have gotten to the end of this. It's a traffic rule question. I'm just curious what you do when you come, say there's multi lanes, there's two red lights, you want to go straight, and then there's a red arrow. It's red arrow. Do you treat the red arrow? Do you go right on red arrow after stop, or do you wait for it to go green?
No, right on red arrow after stop.
So right on red arrow is the same as right on red regular light.
That's what I believe.
Okay, good.
Do we have any police officers that can tell us whether we're correct? That sounds right.
I get mixed reviews on that, but I think, if you don't, people behind you toot your horn. If you're waiting for the green, they go, meh, meh, meh. So I'm going to operate like you from now on. I'm going to.
Well,
Right on
don't
the
tell them it's
arrow.
on the advice of counsel, okay?
My problem always was, why have yarrow if it didn't have some special meaning? Why not just have it be a red light? It's clear this lane goes that way and it has a red light. Why? I thought there might be some different rule about the yarrow. Good. All right. So we've cleared up a lot today, including the traffic rule. Thank you very much. As always, this is a
Thanks,
great
Bradley.
excuse for me to maintain my relationship with you. And there are a lot of people who say, well, my brother included, when are you going to have the dean back on? And Lola Pope looks forward to your appearances as well. You are dean of the Massachusetts School of Law. I always like to check in on how school is briefly before we go. It's you're wrapping up. People are getting ready for their finals at the Massachusetts School of Law.
Yep. And we're going to have at 12:15 today, we're going to have a discussion on the jury and paneling process, jury selection process, from both the Trump perspective and the Karen Reed case. So this is giving us fertile ground to really educate students about peremptory challenges and prospective jurors and what you try to look for, and specifically in a case-by-case basis. So it's a fertile ground. People have a great deal of interest in both of these cases. And it's amazing to me when you think about it, at least from around here, the Karen Reed case has gotten even more high profile than a former president being tried with witnesses, villains and victims and porn stars. But her case takes precedence from at least around here.
I did learn one thing interesting today about jury selection I did not know. And that was, in some cases, they come in en masse, and other cases they come in one at a time. And the strategy varies depending on that situation. One's called the flop, and then one's called something else.
Yes, it's actually, and the process itself varies not just from state to state, state to federal, and even among various Superior Court judges in Massachusetts. They'll use different processes depending on what they feel is the most efficient and viable way to do it. We tried one in Philadelphia, actually, where the jury selection process, there was no judge present during jury selection. So the lawyers had free rein to ask whatever they wanted of the various potential jurors. And it was a little unruly, frankly. So a lot of judges obviously are much more involved in that process. And what we're seeing here in Karen Reed is really a juror by juror, other than, okay, who has biases and who has already made up their mind in this case. And as we've said before, it's not that you've got information about the case already, because everyone has heard about the Trump case and most people have heard about Karen Reed's case. The question is, despite what you know, can you set that aside and rule on the case only on the evidence introduced at trial? And so that's why that's why you can get a jury even in a Trump case, even in a Karen Reed case, is that if people are able to put that aside and just rule on the evidence, then you'll ultimately, hopefully, have a fairer jury, even though there are always problems potentially with that selection process.
Well, I'm going to let you get back to your job.
Okay.
Thank you very much for your time. I know it's a busy time for you. Thanks for doing this. And pretty soon your summer will start, and I know you'll go fishing, and you'll do those things that you love to do. And I hope you have lots of good weather and good health to do those in. So thank you very much.
You as well, Bradley. It's great talking to you.
Bye-bye. And we'll be